Ang susunod na programa ay rated PG. Patnubay at gabay ng magulang ay kailangan sa mga batang manonood.
Magandang gabi Pilipinas at sa ating mga suking taga-subaybay sa programang nagbibigay lunas sa inyong problemang legal. Sa anumang problemang inyong pinapasan, batas ang sandigan. Mangyaring po lamang na idunogay inyong mga problemang pinapasan sa aming opisina through our email batas.sandigan@provrem.com. Ngayong gabi ay babasahin natin ang dalawang liham mula sa ating mga taga-subaybay. Ang unang liham ay mula sa isang private citizen na dumulog sa ating opisina dahil kinuha ng lokal na pamahalaan ang kanyang lupain para tayuan ng isang pampublikong paaralan. Pero hanggang ngayon ay wala pa ring natanggap na kaukulang bayad ang ating letter sender. Tayo ay sasamahan ng ating mga kaibigang abogado na sina Atty. Jethro Odoy, Atty. Paolo Coquilla, and of course, Atty. Lady April Arangcon. Good evening sa inyo mga kaibigan nating abogado.
Good evening, Doc.
Alright, at ito ang liham ng ating letter sender. Dear Batas ang Sandigan, tanong lang po, meron po akong pagmamay-ari na bakanting lote na aking nabili from a good old friend. Dumulog po ako sa inyo kasi gusto po itong kunin ng lokal na pamahalaan para tayuan ng isang public elementary school. Nabili ko po ang lupa sa halagang 100 milyon. Hanggang ngayon ay hindi pa rin po ako nababayaran ng LGU. Ano po ba ang nararapat kong gawin? Paano po ba kinukompute ang ibabayad sa akin ng LGU? Ano po ba ang basihan? Nung panahon po ba na nabili ko ang lupa o nung panahon na kinuha ng pamahalaan ang lupa sa akin? Marami pong salamat. Para sa ating mga eksperto, ano po ba ang legal na aspeto na dapat nating tingnan base sa sulat na ito ng ating letter sender?
Maraming salamat, Doc. Medyo complicated siya na problema, Doc. Pero unang-una sa lahat, tingnan natin ang batas ukol sa expropriation. Itong expropriation, nakasad ito sa Rule 67. At ayon sa Section 1 ng Rule 67, dapat mag-file ng verified complaint ang nag-e-expropriate para ipakita ang layunin at karapatan ng expropriation. Dapat din isama ang lahat ng may-ari o may claim sa property na expropriate.
Alright, thank you so much, Atty. Udoy. So kung may verified complaint na na-file, ano po ba yung mga susunod na mga steps?
Dapat nating tandaan na pagkatapos mag-file ng complaint, ang nag-e-expropriate ay may karapatan ng pumasok sa property kung magde-deposit ng halaga na katumbas ng assessed value ng property. Ito ay isang prerequisite bago makapasok ang nag-e-expropriate ng property.
Alright, pero ang tanong ng ating mga taga-subaybay, hanggang ngayon ay hindi pa siya nababayaran. Yung letter sender natin hindi pa rin nababayaran ng pamahalaan. Ano ba ang dapat niyang gawin?
Yun nga. Kapag ganun na nangyari, no, mga tagapakinig, kapag wala namang depensa o objection ang may-ari ng property, maaari siyang mag-file. Ano bang ipa-file niya? Ito, ang Notice of Appearance at Manifestation. Pero kung mayroong depensa, dapat mag-file siya ng answer na naglalaman ng lahat ng depensa at objections.
Okay, so ano po ba yung mga proseso pagkatapos nito?
Mahalaga ito, Doc, kasi katulad ng sinabi ni Attorney Paolo, kapag natapos na ang depensa at objections at walang party na nag-appear para depensahan ang property, maaari nang maglabas ng order of expropriation ang korte na nagdideklara na may lawful right ang nag-e-expropriate na kunin ang property para sa public use tulad ng elementary school.
Pero paano naman ito magkakaroon ng tinatawag natin na just compensation o karampatang halaga ng propiedad?
Ganito yan. Ito ay aayusin ng mga commissioners na itatalaga ng korte. Ang kanilang trabaho is to assess ang just compensation based pa rin sa value ng property at ang damages na maaaring maidudulot ng expropriation.
Alright, so you're talking about just compensation, no? Sa pag-expropriate ng property. Ano pala yung just compensation o yung sinasabi natin na karampatang halaga ng propiedad?
Yes, ganito yun, Doc. Ang just compensation ay isang legal na konsepto na nangangahulugang tamang bayad o halaga na dapat bayaran sa may-ari ng property na isinilalim sa proseso ng expropriation o pag-aari ng pamahalaan para sa public use or purpose. Ito ay karapatan ng may-ari ng property na matitiyak na siya ay makakatanggap ng makatarungan at nararapat na bayad para sa pag-aari o paggamit ng kanyang property ng pamahalaan. Sa context ng sulat ng tinatalakay, ang just compensation ay dapat bayaran ng barangay o lungsod sa may-ari ng property na nais kunin para gamitin bilang paaralan base sa liham na ating natanggap. So, ito ay isang paraan para tiyakin na ang may-ari ay hindi mawawalan ng karampatang kabayaran sa kanyang ari-arian at ang proseso ng expropriation ay nararapat at makatarungan. Ang pag-compute ng just compensation ay kadalasang isinasagawa ng mga commissioners na itatalaga ng korte. So, binubuo ito ng mga commissioners ang isang report na naglalaman ng kanilang assessment sa halaga ng property na isinasailalim sa expropriation. So, ito ay maaaring batay sa market value ng property o kasamang ang iba't ibang aspeto tulad ng potential income o mga damages na maidudulot sa may-ari. So mahalaga ang just compensation ay nakatuon sa pagbibigay ng makatarungan at tamang halaga para sa may-ari ng property na naaayon sa batas at prinsipyo ng katarungan.
Alright, napakaganda na explanation hinggil sa kung ano ba yung tinatawag natin na just compensation. Pero paano naman kung hindi sumasang-ayon ang may-ari sa assessment?
Yun nga, yung basehan kumbaga ng assessment, hindi natin kumbaga maipipilit, no? Pero may karapatan talaga ang mga may-ari na mag-file ng objections sa report ng mga commissioner. Sabi ni, kumbaga, kung in accordance pa sa sinabi ni Attorney Arangcon, no? So pagkatapos ng korte ang magdidesisyon kung tatanggapin ito o hindi ang report. Baka ang pinaka-importante lang dito is maipaliwanag ng maayos kumbaga ang basis ng kanilang assessment. So yun yung pinaka-importante doon.
Okay, thank you so much. Mayroon pa bang ibang importanteng aspeto na dapat malaman ng ating mga taga-subaybay, most especially sa letter sender natin tonight?
Oo, mahalaga yung explanation ni Attorney Ladyh kasi ang just compensation, nararapat lang niyang ibayad ng nag-expropriate. So kapag isa katuparan na ang expropriation, dapat bayaran ng nag-expropriate ang just compensation tulad ng sinabi ni Ladyh kung paano yun kinompute. Kapag ito ay nagawa na, may karapatan na siyang pumasok sa property at gamitin ito para sa public use o purpose, okay, tulad ng public school or elementary school.
Okay, so maraming salamat sa inyong pagsagot sa katanungan ng ating letter sender. Sana ay naliwanagan din ang ating mga taga-subaybay hinggil sa proseso ng expropriation. Kung kayo po ay may mga katanungan, huwag mag-atubiling itanong sa aming social media accounts o ipadala ang inyong mga sulat. Maraming salamat po sa inyong pagtutok. At ngayon po naman ay mas lalo pa nating ipaliwanag sa lahat kung ano yung mga detalye ng Rule 67 sa expropriation. Tatalakayin natin ito ng mas maigi kasama ang ating mga eksperto. Unahin natin si Ma'am Lady April. Maaari niyo po bang ipaliwanag ng mas detalyado ang Section 2 ng Rule 67 tungkol sa entry ng plaintiff sa property at ang tinatawag nating depositing of value?
Oh, syempre naman. Ayon sa ating batas, sa Section 2 ng Rule 67, pagkatapos mag-file ng complaint, may karapatan na ang nag-e-expropriate na pumasok sa property kung magde-deposit ng halaga na katumbas ng assessed value ng property. So ito ay isang security o seguridad para sa defendant na may sapat na pondo ang nag-e-expropriate para bayaran ang just compensation.
At paano naman po ito mag-a-apply sa mga personal na property?
Pagka personal property yung pinag-uusapan natin, no, dapat ma-provisionally ascertain ang value nito. At saka ang halaga nito dapat ay idideposito natin sa dapat agad na itinakda ng korte.
Okay. Napakalinaw po, Attorney Coquilla. Ngayon naman, maaari niyo po bang ipaliwanag ang Section 3 tungkol naman sa mga defenses at objection ng defendant?
Oo, mahalaga ito ang Section 3. Ayon sa Section 3 ng Rule 67, kung walang depensa o objection ang defendant, maaari siyang mag-file ng Notice of Appearance at manifestation ng kanyang walang depensa. Ngunit kung mayroong depensa naman, kailangan niyang mag-file ng answer na naglalaman ng kanyang mga depensa at objections.
Maraming salamat po. Ano naman ang mangyayari kung hindi siya mag-file ng kanyang depensa?
Okay. Dapat nating tandaan na kung hindi siya magpa-file ng depensa, maaari siyang mag-waive ng kanyang karapatan sa mga depensa at objection. So, subalit, maaaring payagan ng korte ang amendment sa kanyang answer bago maglabas ng final decision.
Alright, salamat po, Attorney Arangcon. Ngayon, parang hindi pa natin nasagot yung core ng question ng ating letter sender. Ano po ba yung basihan para sa halaga na dapat ibabayad sa ating letter sender?
Okay. Look at the first paragraph sa Section 4 sa ating batas. Ayon sa ating batas, payment of just compensation to determine as of the date of the taking of the property or the filing of the complaint, whichever came first. So ayun, whichever came first. So if the filing was ahead of the taking, the value is as of the time of filing. But if the property was taken as early as 1920 and the government is filing the case as for the first time now to correct its mistake, they will pay you based on the price in 1920.
Maraming salamat po sa paglilinaw ng ating mga kaibigang abogado na sina Attorney Ladyh Apil Arangcon, Attorney Jethro Odoy, and Attorney Paolo Coquilla. Kung mayroon kayong mga tanong, huwag mag-atubiling sumangguni sa amin. At sa ating pagbabalik, isa na namang liham ang ating babasahin at pasanin na bibigyan ng lunas. Pakatutukan sa pagbabalik ng Batas ang Sandigan. Kayo ay nakatutok pa rin sa Batas ang Sandigan. At para sa ating ikalawang liham na babasahin, sasamahan tayo ng ating mga kaibigang abogado na sina Attorney Eryel Legis Comania, Attorney Rey Codilla, Attorney Edzrapil Apil, and Attorney Deanne Aubrey Salcedo. Ang ikalawang liham ay mula sa isang chief accountant sa isang pampublikong opisina na ayon pa sa kanya, siya ay tinanggal sa kanyang pwesto dahil sa mga mabibigat na akusasyon. At ito po ang kanyang liham. Dear Batas ang Sandigan, on December 7, 2021, the Ombudsman filed charges against me. I served as the chief accountant sa isang government agency. Pinatalsik ako sa aking pwesto dahil sa mga aligasyong dishonesty, grave misconduct, and conduct prejudicial to the service dahil daw sa false declarations in my financial statements. On January 4, 2023, I was reassigned to another department. Meanwhile, another officer assumed my prior role as per the same order. However, the situation escalated when the Ombudsman placed me under a 6-month preventive suspension, culminating my dismissal from service on December 10, 2022. I contested this decision through a pending motion for reconsideration. In an attempt to reclaim my former position, I sought an advice from a lawyer who told me that I shall file a petition for co-warranto against my successor. Pero hindi ko kabisado ang co-warranto. Ano po ba ang maipapayo ninyo sa akin?
So ayan, no? It is as if our letter sender is asking if it is proper to file a petition for co-warranto. So to our viewers, please note that our advice only depends on the facts provided.
Before we give our advice on the subject matter, I think it is important for us to talk about what is co-warranto in the first place. So I guess it is safe to say that the remedy of co-warranto may not be a familiar concept with those who do not have legal background. And I think it only became a daily talk about term during the proceedings, leading to the ouster of then Chief Justice Maria Lourdes Sereno. So, Attorney John Ray, what is co-warranto?
Actually, we could find the co-warranto petition under Rule 66 of the Rules of Court. And a co-warranto petition is generally defined as an action against a person who usurps, intrudes into, or unlawfully holds or exercises public office. So in other words, if someone holds a public office or a corporate position, in case of corporations, no, but he doesn't have that title or right over that position, and someone has a better right or title to that position, that particular person can be ousted or removed from office through a co-warranto petition under Rule 66 of the Rules of Court.
So going back to the letter sender, no, it appears that you cannot successfully avail of the remedy of co-warranto. So that same definition was used in the case of Moro versus Del Castillo Jr. So the court cited in that case in the matter to declare in contempt of court, Honorable Simeon A. Datumanong, Section 7, Rule 3 of Administrative Order as amended clearly provides that an appeal shall not stop a decision of the ombudsman from being executory. So, executory na kaagad siya, meaning yung removal is valid, so wala ka ng karapatan sa posisyon. Na yan unless the position remains unfilled and the ombudsman reinstates you to such position by a subsequent order.
That's correct, Attorney Salcedo. No? The Supreme Court even reiterated that ruling in the case of Office of the Ombudsman versus Court of Appeals. The Supreme Court said in that particular case that in a co-warranto petition, the petitioner who files the action in his name, in his own name, must properly establish or prove that he is entitled to the subject public office. Otherwise, your case will be dismissed if you cannot properly establish that you really have the title to that particular office you are fighting for. Now here, our letter sender brought the action for co-warranto in his own name. And that's already, if we count it until today, from the ouster or from the removal from office, that's more than a year the ombudsman ordered his dismissal from service. So as explained by the Supreme Court in various rulings, the dismissal order from the ombudsman was immediately executory even pending appeal. So by that, natanggalan na siya ng right over that position. Consequently with this, he already has no right to pursue the action for co-warranto, and of course, he cannot already reassume the position of chief accountant in that particular agency.
Exactly. I so agree with you. And I want to pick up some points that you raised with regard to the title of the petitioner to file a co-warranto petition. It is important to, in this proceeding, co-warranto proceeding, that the person instituting the co-warranto petition has a title to the position or public office that he is seeking to occupy. So kung wala ka namang title over that position, then you cannot avail of this remedy. But I think it is important also for us to note that the petition for co-warranto is only available within 1 year after the cause of ouster or at the time that you were appointed to such office arose. So if you are ousted on December 1, 2023, you only have until December 1 of 2024 to file a petition for co-warranto. Or if you're appointed to a position on the same date, December 1, 2023, and then somebody there don't want to leave that office, so you are forced to file a petition for co-warranto, you only have until December 1 of 2024 to institute such proceeding. After that, you cannot anymore avail of this remedy.
But what happened in the case of then Chief Justice Sereno? She was in office for years, right? Yet, co-warranto lies against her. Why is not the 1-year period applied?
So you are correct, Doc Mervs, no? In fact, the Chief Justice Sereno was holding office for more than 5 years. So that's because we have to note that there is an exception to the 1-year prescriptive period. So in the Sereno case, we have to remember that the Supreme Court said that quo warranto may still be availed of even after the prescriptive period. So if it is filed by the state at its own instance through the Solicitor General.
You're correct, Attorney Deanne. If we revisit the case of Sereno, actually, the petition for quo warranto was filed by Solicitor General Jose Calida on March 5, 2018, on the grounds that then Chief Justice Sereno is not a person of integrity because she filed her SALN during the times that she taught at UP College of Law. So basically, yung integrity na yung ina-attack ng Solicitor General. So if you don't have integrity as one of the requisites, if we can still remember our law school days, may discussions tayo dyan about the qualifications of judges and chief justices. So integrity is one of those. Kung hindi ka naman nag-file, you violated the law, then your integrity is very questionable. And that is why Jose Calida, Solicitor General Jose Calida was saying, oh, Chief Justice Sereno, you don't have integrity, you don't have a right to occupy the Chief Justice post. Therefore, I am instituting this petition for quo warranto for you to vacate that position.
Kaya pala. But is it okay that there's an ongoing impeachment in the House of the Representatives and then you have the quo warranto in the Supreme Court? Kasi I remember there was an ongoing impeachment proceedings before the House of the Representatives and then the Solicitor General filed a quo warranto case before the Supreme Court. Pwede ba sila isabay?
Pwede. Pwede, Doc Mervin. Actually, quo warranto and impeachment are two distinct remedies. They may proceed simultaneously. So, kahit may ongoing impeachment proceedings against you, the state can very well institute a quo warranto proceeding simultaneously with impeachment.
So since we are talking about quo warranto over and versus the impeachment complaints, it is also worth noting in the case of Sereno, then Chief Justice Sereno, that the Supreme Court said that a quo warranto petition can only be availed of if the grounds are acts or omissions prior to the time of appointment or election, while if the grounds are acts of omissions during the incumbency or during the time ng panunungkulan, then a quo warranto petition could not be the proper remedy. Maybe other cases like the impeachment complaint.
So, however, no, we have to emphasize that in the case of our letter sender, even if we assume na right action ang quo warranto in his case, still it cannot prosper considering na his right to file the action for quo warranto has already prescribed.
So, additional information lang sa ating mga viewers, no? Kahit sino ba ay pwede mag-file ng quo warranto petition?
So for that matter, Doc Mervs, not anyone can file the quo warranto petition. May tinatawag tayo dyan na real party in interest. So under Rule 3, Section 2 of the Rules of Court, ang real party in interest is the one who stands to be benefited or injured by the judgment in the suit or a party entitled to the avails of the suit.
So in other words, if the quo warranto is filed under Sections 2 and 3 of Rule 66, and it was commenced by the Solicitor General or the public prosecutor, the real party in interest is the Republic of the Philippines. On the other hand, if the action is under Section 5 of Rule 66, the real party in interest there is the person claiming to be entitled of the office or position usurped or unlawfully held or exercised by another who brings the action in his own name.
What about this scenario? If the principal of a public high school is illegally replaced by another, is it a requirement that before he can go to court on a quo warranto petition, he should first exhaust administrative remedies?
In that case, no, it is not required under Rule 66 of the Rules of Court that we have to exhaust the administrative remedies before we could file an action for quo warranto under Rule 66. The Supreme Court actually emphasized in the case of Corpus versus Quaderno that exhaustion of administrative remedies does not bar nor become a hindrance for a person to file a quo warranto petition under Rule 66 of the Rules of Court.
Ayan, we've addressed your question based on the facts you gave us. Our guest simplified it so viewers in similar situations can easily know what steps to take. Thank you so much ating mga guests for tonight. We have Attorney Deanne Aubrey Salcedo, Attorney Eryel Legis Comania, Attorney Rey Codilla, and of course, Attorney Edzrapil Apil. Kami po ay umaasa na marami kayong natutunan sa ating episode tungkol sa expropriation and co-warranto. Hanggang sa muli, ako po ang inyong lingkod, Mervin Jay Z. Suaybaguio. Sa anumang problemang inyong pasan, batas ang sandigan.